Yes, I'm sorry, I don't know what's happened to the clock. So I don't know whether I should apologise for being such a date or not. Just one moment. Yes.
Two points arising from this morning's exchanges, my Lord, if I may.
Yes.
First, Justice Peter Jackson mentioned there being some evidence on disciplinary proceedings against doctors in relation to Section 11D. The evidence is in Mr. Argent's second statement at page 217 of the supplementary bundle, and it is concerned with doctors' performance of late-term abortions. So once the abortion has been approved, the procedure that they've used and the way that they've conducted the procedure, it's not about the decision to approve it in the first place. And secondly, my Lord Justice Underhill asked me for authority on whether professional guidance or ethical guidance could count for the purposes of in accordance with the law. I haven't got a case specifically on professional guidance, but I have a reference on the overarching test for what constitutes the law, which is in a House of Lords case called Munjaz and Ashworth, 2006, 2 appeal cases 148, paragraphs 34 and 91. And the point made in those paragraphs is that the law is anything which has some basis in law. It need not be statute. It may be a code of practice, as in that case, but it was a statutory code of practice which had a basis in statute. It can be the common law, it can be judicial decisions. But on the test in that case, although that wasn't the issue in that case, on the test in that case.
Thank you, that's helpful. If Ms. Smith has discovered anything else, she'll tell me in the course of her submissions. Yes.
Thank you. I was on factors which should serve to narrow the Strasbourg margin of appreciation, and the factor I was going to mention lastly was the CRPD, which is referred to in our skeleton argument, para 36, subparagraph 2. And it is clear from Guberina and Croatia that the content of the CRPD, which has been signed up to by all of the Council of Europe states, is of significance to the Strasbourg Court when it comes to identifying the ambit of the margin of appreciation. Could I ask you to look at the Guberina case, please? It is in bundle 2 and in tab 17.
Yes.
And the case was about a tax benefit or withholding of a tax benefit from a man who bought a property which was adapted to the needs of his disabled child, and he sought and was denied a tax benefit in relation to that property. I think I referred to you earlier on, but didn't take you to paragraph 73 on 1388, which
yes.
is the point on narrow, or substantially narrow margin.
Very familiar passage. Yeah.
And then the CRPD point is paragraph 92 in the context of justification and applying the law to the facts, the Strasbourg court relies on the CRPD and the fact that Croatia in that case had signed up and ratified the CRPD, but then had not considered it in relation to this particular legislation.
Okay.
Having, we say, erroneously identified a broad Strasbourg margin of appreciation, the divisional court moved on in paragraph 124 to say that in the domestic constitutional context, Parliament should have a wide margin of judgment. And the short point on this paragraph, 124, is how this court interprets the Supreme Court and the dicta from the Supreme Court in Northern Ireland Human Rights Commission, whether you interpret those dicta as being relevant to abortion as an issue, and so including relevant to this case, or whether you accept the respondent's submission that the dicta must be read in the light of the particular issue in that case, which was a restrictive Northern Irish position on abortion, and the Supreme Court holding that the law needed to be to go further in order to be compatible. Now we rely, and if I could ask you to look at paragraph 39 of our skeleton argument, we rely on Baroness Hale, and it's bundle 1, tab 13, at page 299 of the authorities bundle.
Yes.
I'm accused of altering the meaning of what she said by my square brackets at the beginning of the quotation in the skeleton, so I better show you the quote in the original, paragraph 38. Baroness Hale says, "This is not a matter on which the democratic legislature enjoys a unique competence." And this is not a matter. Well, one starts with paragraph 35 to look at the issues in the case. But we say the matter is availability of abortion. It is a matter of fundamental human rights on which, difficult though it is, the courts are as well qualified to judge as is the legislature. In fact, in some ways, the courts may be thought better qualified because they're able to weigh the evidence, the legal materials and the arguments in a dispassionate manner without the external pressures to which legislators may be subject. Now, that reasoning is one which applies equally whether the issue is that abortion should be more widely available or less widely available. It's the nature of the issue of the nature of the matter that Lady Hale is referring to. And Lord Mance at paragraph 120 on page 333, and Lord Kerr between 289 and 300 on page 374 also found the area of judgment to be sufficiently narrow to find that the Northern Irish law was incompatible. So that is the approach of the divisional court. Broad margin in Strasbourg, broad margin domestically, and then it comes to apply the proportionality test in paragraphs 125 onwards. And 125, you will have seen the complaint in my skeleton argument that it should not be regarded as a positive virtue of Section 11D that, as the Divisional Court says, Parliament gives a choice to women, it does not impose its will upon them. I don't want to be unkind or to willfully misread what they are saying, but we don't see how it can be a positive virtue that there is a choice whether to have an abortion or not, as opposed to being told, for example, that you must have an abortion. But we say, in any event, and not a significant part of the reasoning. 126, then, they say the evidence is also clear that although scientific developments have improved, an earlier identification may be feasible, there are still conditions which would only be identified late in pregnancy after 24 weeks. Pausing there, the may be feasible is a significant understatement of the position in relation to many conditions, and certainly in relation to Down syndrome. You have evidence, and it's in the evidence of Professor Clark, as to the 9 and 11 week tests that can be done for Down syndrome. So that is a significant understatement. And the Divisional Court in this paragraph, or indeed the following paragraph, simply doesn't address the submission that Section 11D is overbroad because it doesn't distinguish between conditions which can be identified prior to 24 weeks and therefore could come within Section 11A, and for which Section 11D may not be necessary, and other conditions which can't be identified until much later in pregnancy. And that's again one of the ways in which we would say that if Parliament is invited to look again at Section 11D, that it ought to be distinguishing between conditions which are detectable, where one doesn't need the unlimited time span, and conditions which aren't. The second sentence of paragraph 126, citing the professor saying that there will be circumstances where a woman only becomes aware of the pregnancy very late on in that pregnancy. Well, that is true, but it's also true for the able-bodied fetus, and Section 11A sets a cut-off point. What's the difference? And then 127 is the argument about whether it's possible to have an exhaustive list of conditions which fall within Section 11D, where the Divisional Court accepts the evidence of the respondent that that's not feasible.
Yes, sorry to interrupt you. I hadn't focused on the last sentence of 126. In reading it previously, I had misread it as meaning that the woman only became aware of the condition very late on in the pregnancy. Isn't that what is actually meant by this, rather than late discovered pregnancies?
I believe it is late discovered pregnancies.
Right. But it is late discovered conditions, which would seem to be a more powerful argument,
yes,
mentioned elsewhere, or is there a possibility that that's just simply a misspeaking?
I believe it's mentioned elsewhere.
All right.
Well, that's mentioned in the previous sentence for a start.
Yes.
Yeah.
But my
I doubt if this is going to turn, frankly.
No.
And your time is, you'll have to prioritise which points you develop, Mr.
Yes.
Koppel.
The only point on 127 then is that the respondent has slipped into paragraph 62 of its skeleton argument that the reasoning in 127 applies both to an inclusory and an exclusory list. Whereas what is being addressed in 127 and what's addressed in the evidence of the professor is an inclusory list, i.e. an exhaustive list of conditions which will be covered by section 11D. The select committee didn't address, he hasn't addressed, and the divisional court didn't address our submission that one could exclude certain conditions, for example, because they are detectable early in pregnancy. My final topic then is issues which the divisional court did not weigh in the balance. That's their express reasoning on proportionality. Issues which they did not weigh in the balance, the impact upon disabled persons such as my clients, I mentioned that this morning, which is not expressly taken into account. Secondly, the rights and interests of the unborn child, and we've had an exchange about the relevance of that, or indeed the community interest in the protection of unborn life. And thirdly, see paragraph 47 of our skeleton argument. We cite Lord Kerr in the Northern Irish case, paragraph 331, saying that the imperative from the CRPD that there should be no discrimination on the basis that the fetus, because of a defect, will result in a child being born with a physical or mental disability, he said was a weighty factor to place in the balance, to place in the proportionality balance. Now, of course, different issue in that case, but nevertheless a weighty factor, the clear position under the CRPD, which of course long postdates the relevant provisions. And the divisional court did not take into account, for reasons that it dismissed the argument in accordance with the law stage, did not take into account the defects that we pressed under that head, and which would also be relevant to proportionality if you're not with me on in accordance with the law. Those are my submissions, unless I can assist further. My client has not returned, but we'll take it that she won't seek to address the court.
Very well. Thank you very much indeed, Mr. Robb, for those helpful submissions. Yes, Ms. Smith.
I'm grateful, my Lord. The ultimate question which underlies this appeal is where society should set the limits in criminalising women for the choices they make in deciding whether or not to have an abortion. And obviously that raises profound social, moral and ethical questions, and there are irreconcilable views on all sides of the debate. The reason I make that point is that the issue is so sensitive and controversial that successive governments, including this one, have not taken a policy position. So this is a matter of conscience, and there is a free vote in Parliament on the issue. Now, the headline response to the appeal is this, that the court will have seen that we don't accept that the building blocks of the appellant's case are made out, but the headline point is really that this is and must be a matter for Parliament. It's the paradigm case we submit. The other general point, and it will feature in my submissions as I go along, is that it's very necessary in relation to each and every ground to focus on what is actually an issue on this appeal. This is not a broader challenge to section 11D more generally. Before I launch into my submissions, could I just make this point, that I hope that it's clear from our evidence that the Secretary of State is acutely aware of the human background to this case. And the Secretary of State absolutely acknowledges the powerful sentiments which have been expressed by the appellants and their supporters. they are points which have been made in compelling terms in parliamentary debates, and they have been countered in equally compelling terms by those who take a different view. And just for the court to note, that is addressed in detail in Miss Duncan's witness statement, which is in the supplementary bundle, and it's the part of her witness statement which is at pages 105 to 122.
Yes, those extracts from Hansard were all that were before the divisional court as well, I'm assuming.
Yes. Well, the court had actually bigger attachments, but we didn't presume to include them in the bundles for this court, but we picked out the main features in the evidence. So attached to the statement...
Well, all I was really getting at was, did the court below have the full debates in Hansard?
Yes. It had them as attachments. They were attached. I'm just asking Mr. Vanderman to check, but yes, the witness statements had attachments to them, I believe.
Well,
but the statement goes into some detail and sets them out, effectively the key extracts. Not all of them, because there has been a lot of debate.
yes.
In the exhibit...
I think one moment we just got people coming in. I think it'll...
Sorry.
Don't worry at all. Don't worry at all. Yes, Ms. Smith.
Yes, my lord. So just to clarify, the exhibits to Miss Duncan's witness statement actually attached debates from Hansard, but the witness statement set out extracts in fairly full detail. So we haven't provided everything to this court. That can certainly be provided, but we had in mind that the court doesn't want to see huge swathes of material.
Well, I think that's probably right. I don't rule out the possibility that we may, when we come to consider, want to see the full materials that before the court below, but both parties have proceeded on the basis we've seen all we need for the purpose of this appeal.
Yes, okay. But those debates in the statement show the very points that are being made in this claim being made by parliamentarians. So with that introduction, I'll then take my submissions in 5 parts, if I may. So first, I'll deal with some factual matters and some matters of context. Second, I'll address the question of whether there is an interference with rights protected by Article 8, which is ground 1. Third, and taking the grounds out of order, I'll address the in accordance with the law question. Fourth, I'll very briefly deal with a discrete point on Article 14. And then finally, I will address proportionality. So taking matters in that order, could I make 5 points about fact and evidence? And I'll just give the court the references if I may. So the first point is about Down syndrome. That's dealt with in the judgment at paragraph 9. But for additional context, could I invite the court just to note Professor Tila Ganathan's statement at paragraphs 43 to 49, and that's at paragraphs 150.
For which paragraphs did you say?
43 to 49, supplementary bundle pages 152 to 154, and he says that he's concerned that the court should have a full picture, and that's where he sets that out in his statement. The second point is to make a point about statistics and the use of section 11D in cases after 24 weeks. So first, there is paragraph 25 of the Divisional Court's judgment. But could I just invite the court to turn up Andrea Duncan's statement at pages 125 to 126 of the supplementary bundle.
I'm sorry, I'm afraid we can't have a child in court if she's going to make noise. I'm sorry if that's a nuisance for you, but that's how it has to be done.
Talking to me. So paragraph 41 of her statement under the heading data, She deals with the 2019 statistics, and she says that a small number take place at 24 weeks gestation and beyond. And just so that the court is aware of the scale of this, it's 275.
I'm so sorry. We just had that distraction. Whose witness statement is this?
This is Andrea Duncan.
Andrea Duncan's, yes, I see.
She's a...
Can I repeat my plea? I don't know who is responsible. It is very useful to have tabs in these bundles. I don't know who was responsible, but can they not do that again? Yes, okay, I found the front of the statement, and now we're on page
125.
125, yep.
So first of all, she sets out in paragraph 41 that 91.3% of terminations for fetal abnormality took place before 24 weeks. And then she said a small number took place at 24 weeks, and that was 275 in 2019. So on any view, this is not something that happens commonly. And then she sets out some more specific statistics that she explains in paragraph 42 of her witness statement. Some of these are unpublished, and the department doesn't have any plans to publish them, but paragraph 42b sets out the data in 2019 in each week from 24 weeks onwards where Down syndrome is mentioned as the reason for termination, either...
Yes, well, speaking for myself, I saw this in my pre-reading. What's the particular point?
The particular point is this, that some suggestion in the appellant's written evidence and perhaps underpinning some of the oral submissions is that this is happening frequently or it's used nightly. We submit that one has to start with the statistics and it's clear that it's certainly not commonly used. The third point relates to late diagnosis and the impact on women of these issues. That's dealt with in paragraphs 26 to 29 of the judgment. But again, I don't need to ask the court to turn this up, but for the court to know, Professor Thieleganathan's statement, paragraphs 41 to 42 and 71, and the statement from Jane Fisher, which is the relevant part is at page 98, paragraph 16 onwards. The fourth point of context, and it was linked to my second, and it goes to the point that the suggestion that section 11D might be lightly used by doctors. Professor Thieleganathan has dealt with that in strong terms in his statement, and again for the court to note, it's paragraph 66 at page 158 and paragraph 82. It goes to the point that I'll be making later, that doctors have professional obligations, and the suggestion that this power is lightly used for things like cleft palate is simply wrong, and that's the part of our evidence which addresses it. And then the final point of context is simply to invite the court. I'm not going to take the court back to the guidance, but I would invite the court, as I think the court has been doing, to read chapter 3 of the RCOG guidance as a whole, rather than picking out particular passages, because that's obviously how it should be read, and it's directed to doctors with professional obligations. So those are the key points that we highlight, and I'll highlight some additional points as we go through where they're particularly relevant. Could I turn then to the second part of my submissions, which is to address Article 8 and the question of interference. In response to the question from the court about is Article 8 engaged at all, or is Article 8 applicable, the Secretary of State has never taken the point in this case that it wasn't. It's an interesting point because often that issue simply isn't discussed in case law, and often the courts will use the word engaged where one might talk about an interference. It's a distinction that perhaps more commonly crops up in the immigration context.
Yes.
I found it in all of these authorities that we have. I found the distinction mentioned in only one of them. But in any event, the Secretary of State doesn't take the point that Article 8 isn't applicable or it's not engaged, we went straight to interference, and we're content to proceed on the basis that it's engaged because of what's said about the impact on self-worth and so on, that it touches on those aspects of private life. And we take that, it's perhaps that the more important point we submit is whether there was an interference. And one doesn't know, because a case like this, as far as I'm aware, has never come before the court, whether the Court of Human Rights would say, well, this is so far removed from what we had in mind in our negative stereotyping cases, it simply doesn't apply. One doesn't know because it's never been considered. But the point is this, that we are content to proceed on the basis that it applies, but we say there certainly is no interference.
Could I, if I may, just press the pause button at that point, because speaking for myself, it doesn't seem to me to be entirely satisfactory to leave the question of whether the right is engaged without reaching a view about it. I mean, surely people are entitled to know whether they've got a right, even if for one reason or another any interference with it is something that they're going to have to put up with. I mean, is it really satisfactory that one says, we needn't worry about whether you've got the right and we'll just consider whether there's an interference with it if you have, or on the basis that the Secretary of State puts it in a negative way, saying we've never argued you don't have it. I mean, surely we need to do better than that, don't we?
Yeah, can I answer it in this way? Because all of us in this room have a right not to be subject to negative stereotyping, whether or not that right...
Do we? I mean, it all rather depends.
Well, for example...
There are some negative stereotypes about lawyers, but I'm not sure that those necessarily engage Article 8.
Well, yes, I mean, I speaking for myself, without one may or may not have very personal circumstances which could be the subject of negative stereotyping. The point is this, that there is a right in principle not to be subject to negative stereotyping. The very fact that the court is asking me these questions...
You keep saying there is a right in, but you've got to be more specific than that, haven't you?
Well, I will be doing that by taking the court to the case law, because what I say is this. I mean, the headline point that I'm going to make is that the Ulla principle, which has been repeated by the court several times recently, that the domestic courts mustn't go further than they can be confident that the European court would go, very much applies to interference just as much as it applies to the other limbs of the argument in this case. And the reason that it's difficult to answer the question in the abstract rather strengthens the Secretary of State's position that this really isn't, that this argument simply doesn't match up to the authorities. So in a sense, what one is arguing in a complete vacuum, because the cases which have been relied on as establishing the principled right not to be subject to negative stereotyping, and which it said has been breached in this case, are so far removed from the facts of this case that it's difficult for me to answer your Lordship's question, because that there simply hasn't been a case like this. In the negative stereotyping cases, there was no question about whether or not Article 8 was engaged. It simply didn't come up.
Is that true in ACSU?
Yes, as I recall, and I'll take the court to... I'm going to take the court to these cases now.
All right.
The court... As I may be proved wrong when I take the court to the case, but the Secretary of State hasn't taken the point that the difficulty
it's just in the interest of clear thinking. I don't care whether the court has previously addressed the point or not. We want to address the point in order that we can understand what we're dealing with. I suspect the answer won't be very difficult. You may be quite wise not to make a fuss about it, but it still helps us. I mean, just to put it, the right which is being asserted is not a general right not to have a negative stereotype. It's about one. It's a right not to have a negative stereotype about being disabled. I'm not quite sure what the right verb is, imposed on one or attached to one, or in any event, not to be subject to, perhaps, a negative stereotype about being disabled. But that's just the kind of accuracy that we're asking for your help on.
Yes, and I can't, I'm happy to accept Mr. Coppell's formulation that Article 8 applies because these are matters that touch on self-worth, dignity, and thus affect private life, and that's simply to repeat what the European Court has said.
Yes, I see. Right. Well, we'll move on from that. Let's get back to where you were going to take us.
Yes. So the point to make at the outset is that we say that the threshold simply isn't met in this case, and we understand that Section 11D can evoke powerful reaction, but that doesn't mean that there's an interference for the purposes of Article 8. So
I'm so sorry, I just didn't hear that. Will you say that again?
The Secretary of State understands that Section 11D can evoke powerful reactions, but that doesn't mean that there's an interference for the purposes of Article 8 ECHR. And to make that good, I'm going to take the court specifically to the case law that the appellants have relied upon.
Yeah.
So the first case is Aksu and Turkey, which is in the, it should be in the second authorities bundle at tab 14.
Yes.
Now, the court has two versions of it, but I'm going to stick with the first version, if I may, but the reported version does appear also at page 1298.
I hadn't noticed that. Well, let's... As long as we use the same one, it doesn't really matter.
So, page 1274 at the top, the court will see that this is about a book called The Gypsies of Turkey. And then at the bottom of page 1275, the first offensive statement says, the last three lines, there are also some, albeit few in number, who make a living from pickpocketing, stealing and selling narcotics.
Sorry, I missed it. Where's that?
It's at right at the bottom of 1275, the last three lines.
Oh, yes, so sorry, I was looking at the wrong page. Yes.
And then over the page, just above the bottom hole punch, under Ankara and then three dots, the gypsies of the central district of Ankara earn their living from stealing, begging, door-to-door selling, fortune-telling and making magical charms. Obviously, the latter is less offensive than the former. It's making living from stealing. And then the appellant's case is captured at paragraph 14, 1277.
Yep.
And then paragraph 44, before we come on to the main test, the court directs itself as to the importance of measures against racial discrimination. That's page 1283. Paragraph 45 says this case isn't about a difference in treatment, as there's no evidence that the publications had a discriminatory intent or effect. So therefore, so no matter what they say, so therefore the question is, did the publications which allegedly contain racist insults constitute an interference with the applicant's right to respect for his private life? Now, unless I've missed it, in answer to your Lordship's earlier question, I don't think there is reference here to applicability.
Well, there wouldn't be. No, that wasn't what I was asking about, but don't worry. The applicant was, did you show us this? Yes, I see. The applicant is of Roma origin and lives in Ankara, right?
And he is understandably offended by those statements. And
These are statements picked out from quite substantial academic treatment.
yes. Yes, but that was his case.
Yes, although it's written by an academic. Yes. It's not quite clear what its status was. It was certainly published by a government ministry.
Yes, although the report explains that this case,
He took the copyright back.
Yeah.
so it's paragraph. So sorry.
It's my fault, but I think we probably shouldn't get too bogged down in this. If your point is it's very different, it clearly is factually very different.
The end of paragraph 60 explains that he didn't pursue his case against the state authorities and why. So the test that Mr. Coppell has cited is set out in paragraph 58. So what the court says is the notion of personal autonomy is an important principle underlying Article 8. It can therefore embrace multiple aspects of a person's physical and social identity, and that includes an individual's ethnic identity. And then it says, in particular, any negative stereotyping of a group when it reaches a certain level is capable of impacting on the group's sense of identity and the feelings and self-confidence of members of the group. It's in that sense that it can be seen as affecting the private life of members of the group. Now, this is a positive obligation case, which the court goes on to decide. We say there are two crucial features in that test. One, negative stereotyping.
Hang on 1 second. Yes.
So one, negative stereotyping, and two, which reaches a certain level. Because this is a positive obligation case, the court doesn't consider interference specifically, but what it says for reasons in paragraph 69 onwards are in effect that there's no positive obligation in this case, and we would say the negative stereotyping case isn't met on the facts.
Sorry, it's obviously very clear to you, and it probably should be very clear to me. Can you just spell out what's the relevance of it being a positive obligation case? I thought there was an interference case, wasn't there?
Not in.
No.
Not
all right.
on this.
Would you just show us where the nature of the application is summarised? You showed us briefly.
It's paragraph 61.
Well, 45. The main issue in the present case, this is what I was thinking of, is whether the impugned publications allegedly contained racial insult constituted interference with his.
Yes. So the court does that in terms of Article 8, but what it then goes on to do is analyse it as a positive interference type case, in which case the language of interference is not generally used. What the court asks.
Sorry, I'm sure this is all very familiar around to you, but it's not to me. In what sense is the language of Article 8 is interference?
It is.
So what positive obligation cases, I always thought, simply meant there will be some cases where it is not enough for the state to say we don't interfere, but where the claimant says and is entitled to say, well, you should have interfered to prevent my rights. Well, we don't intervene. You should have intervened to prevent an interference. But that's just another type of case. I don't quite see what fundamental difference it makes.
Well, it certainly doesn't assist the appellants. I simply make the point because it would be wrong of me to take these remarks and say, they show what I'm saying about the interference in this case. It's right and it's fair to the appellants to say this is a positive obligation case, so the court analyses the issues in a slightly different way. In terms of generally the line between negative and positive cases, that it's a very difficult line to draw sometimes,
quite.
And that's discussed in Elan Kane.
Yes.
But your lordship is right. It's intervene rather than interfere. So, there's a danger. One can it gets very
right.
thick.
But we're getting rather bogged down on this. It's your point.
Yes.
That it's a positive obligation case. I just don't quite understand what difference that
Yes,
makes for our purposes.
No, I'm making the point out of fairness to the
Oh,
appellants.
I see,
That's
okay.
all. I'm so sorry for not being clear. But essentially, the point is that the court doesn't. The court looks at matters in the round and says there was no obligation really on the state to have done anything here. So it doesn't focus specifically on that question in paragraph 58, which is one, is there negative stereotyping, and two, has it reached a certain level? Nonetheless, the point I derive from this case is that ultimately it failed. That the claim was rejected. So no matter what the context, the claim was rejected.
But the point we need to derive from any case is what the principle underlying it was. So I don't understand you to be cavilling with the statement of principle which you took us to earlier.
No.
Under paragraph 58, which cut and pasted from a number of previous decisions.
Indeed.
Because I mean, in effect, the analogue, if we were looking to see what the court made of this sort of situation, would be a statute which said that terminations could be carried out later in the case of Roma people than they were carried out in the case of non-Roma people. And so clearly the case is nowhere near that. But so you're gaining comfort from the fact that the Roma people's rights weren't impinged upon by the publication of some ministry-approved book. Doesn't really help you very much in relation to the issues that we have to consider.
My point, my lord, is this, that this court can't go further than it would be confident that the European Court would go. And what these cases show is that this test has been applied in very exceptional circumstances, effectively positive abuse. And for the appellant...
Well, hang on, you don't prove that by showing that in one particular case it was...
What?
But we haven't shown us all the other cases in which this test, as my lord says, it's pretty clear it's been cut and pasted from earlier cases, like Chubataru in Moldova and Essen Marpa. I've no idea what sorts of cases those were.
Well, I'm about to take your lordship and your ladyship to those cases, but that's to headline again my
But
point.
if you're saying we've no idea what to make of it, I mean, are you saying we have no idea what the court would make of a situation in which termination was available at a later date for people of Roma origin than of other origins?
What I'm
I think we have a perfectly good idea what the court would likely say about that, haven't we?
Yes, although that's not this case. This is a case about a general legislative provision, which is the points I'll make once we've been through the authorities.
Well, that's a different.
It is, but I have to take the court to these cases.
Okay, well, you know what's worrying us, but you're going to address those worries. So where are we going now?
So we're going to tab 16, which is RB and Hungary. And paragraph 10 sets out what happened in that case in a nutshell. So there was racist abuse and threats of violence. And then paragraph 78, again, cites the same test, copied and pasted, nothing new there. The court refers at 79 to treatment which doesn't reach a level of severity sufficient to bring it within the ambit of Article 3.
Which paragraph are you on, sorry?
Paragraph 79. And then again, paragraph 84, the court says, well, the state has to intervene where a person makes credible assertions that they've been subjected to harassment motivated by racism, including verbal assaults and physical threats. And the court goes on to decide that in this case, the criminal mechanisms were defective.
Effective or defective?
Defective.
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 Yes. Right.
Although at paragraph 101, it decides that in relation to the actual rallies, that although that was difficult for the applicant, the response of the police was reasonable and therefore that wasn't a breach of Article 8. So that was the two discrete issues considered. And then finally, the court's already been taken to Lewitt and Austria, which is at tab 18. Again, that's extreme circumstances. The court may recall that was about saying that everybody who had been in the particular concentration camp were robbers, plunderers and murderers. And again, that Mr. Coppell has taken the court to the test. So the reason that I take the court to those cases is this, that the appellant has to make out this case, has to say, well, the European Court would find, in effect, that Section 11D has interfered with our Article 8 rights. But the point we make, and that the Divisional Court accepted, is that these cases are very far from the facts of this case, and I'll come on to make...
Yes, but hang on. The Ulla principle doesn't say that you can only ever find a breach where the Strasbourg case has found a breach on identical or very similar facts. The Ulla principle is about not going further than the Strasbourg case in terms of developing the applicable rules or the applicable principles. If there is a principle of the kind that Mr. Coppell relied on, about negative stereotyping being capable of being an interference with the Article 8 rights of a group because it affects their self-worth, and I'd simply asked to apply it in a different situation, that's perfectly conventional and acceptable and doesn't breach the Ulla approach at all, does it? We sort of decide whether it is so on the facts, or whether, more accurately, whether the Divisional Court should have found that it was so on the facts. But that's all, isn't it?
In principle, yes, but the question here is what does the court mean when it talks about negative stereotyping?
Yeah, well...
What does it mean, negative stereotyping, when it reaches a certain level? And we submit that what these cases show is it's talking about some kind of positively offensive statement of that kind. There is not a single case which says a legislative provision like this is capable of being negative.
Well, let's just unpack that. It doesn't matter, surely, whether it's a legislative principle. You could have a legislative principle that said legislative provision. You could have a legislative provision that said all gypsies, Roma, are second-class citizens. That would be legislative, but it would certainly be a breach of their Article 8 rights. So that's really by the by, isn't it? The real question is the nature of whether this case really does.
Yes.
Well, the facts of this case do show the quite sure what the right word is, the imposition of a negative stereotype.
Indeed, and that...
Sorry?
Perpetuation.
Perpetuation. Well, I'm not sure. My lord, no, I'm not sure. We needn't worry about the exact word for the moment. In your case, as I understand it, is to make a provision in terms of 1.1d does not carry a negative stereotype. I think you accepted that you can understand why in human terms disabled people might feel as if it did, but I think you're saying that doesn't mean that it actually does. Surely that's the point on which I'd like to hear you.
Indeed. Can I then give my 5 reasons as to why I say that's
Yes.
the case? So the first, and it's the first, is that Section 1.1d is a provision which prevents a woman from being prosecuted in the circumstances which it sets out. So the legislation is fundamentally about choices confronting pregnant women and not about any other group. That's the first point.
Hang on 1 second. These 5 propositions don't appear in this precise shape in your skeleton, do they? Even if they do, I just note them up there.
Yes, I've broken it down into...
No, that's
5
fine. No, that's still very helpful. So it's about preventing prosecution of women. Can you just have the whole...
In the circumstances set out in Section 1.1d, the legislation is fundamentally about the choices confronting pregnant women. It's not a provision which is about any other group, and it's certainly not a provision which is intended to stereotype or denigrate any other group. So to take your lordship...
Well, you needn't answer this if it's covered by one of your other 5 points, but what I think is that may all be true, but nevertheless, the necessary implication is that the life of a disabled person has less inherent worth. You're quite right to say that's not what it's setting out to do, but if that's the necessary implication, isn't that enough?
My lord, no, it's not enough, but for the reasons I'll come to.
Right.
But in my submission, that looks at things from the wrong angle, because although that may be how disabled people feel about Section 1.1d, Section 1.1d is about giving a choice to women.
Could you just help on the statement that it relates to choices for women? I understood the 1967 Act as amended to provide defences from the Offences Against the Person Act offence under Section 58, which it might be just worth us looking to see
Yes.
what's going on here.
Yes.
We have it in our authorities bundle at page 1.
Can I just turn my back for a moment?
Yes.
Yes, so Section 58 the court has in the first.
Is that the section we should be looking at?
Yes, so one moment. So tab 1.
So you see, the offence under there appears to be either a woman procuring for herself an abortion, or somebody carrying out an abortion upon her. So surely the effect of the Act is not primarily directed towards, in a world in which these are operations carried out medically.
Yes.
Surely it's the second half of the offence that is particularly relevant, which is the protection of doctors.
Yes, I accept I accept that point.
Right, so actually, it's first and foremost about the protection of doctors acting responsibly.
Yes.
Rather than, as you put it, I mean, it may be, by necessary implication, choices for pregnant women, but that's not the structural effect of the legislation, first and foremost, is it?
Yes, although the point is this, that without section 11D, the woman would not have the ability to have an abortion.
Yes, but
I'm so sorry, I'm just being shown something. Yes, the additional point is that the 1929 Act, and we haven't included this in the bundle, makes it an offence to intentionally kill a child capable of being born alive before it has a life independent of its mother, and that is also qualified in effect by the 1967 Act, and I believe that is set out in the Divisional Court's judgment as well.
It is. It is. I haven't quite understood how they interrelate. I had a feeling, but you'll tell me this is wrong, that section 5 of the 1967 Act was, well, it was changed by the 1990 Act, but there was an equivalent provision before, was there? I.e. the 1967 Act always protected you against prosecution under the 1929 Act.
Yes, it did. Yes, and there's some...
I think it might be useful, if just so that we can get this accurate in our judgments, could we be supplied after this hearing, but a copy of the 1967 Act in its original form?
Yes, we can certainly do that.
Thanks.
There's some explanation of the background in Miss Duncan's witness statement. I believe that may set it out, but we can.
I still think it'd be useful just so we can read across from one to the other easily.
And
Yes,
I'll have a word with Mr. Coppell. If we think that it's not clearly expressed, perhaps we could agree a joint note, just setting out the provisions and how they interact, so that the court has it.
it ought to be clear, but if there is any doubt, of course, we wouldn't reject that. Anyway, let's not get distracted. You're looking very intently at this.
Oh, I'm sorry. I thought I might assist by saying that as originally enacted, I think as the Divisional Court explains in paragraph 14, the 1929 Act was a limit, acted as a limit on the freedoms created by the 1967 Act. So in effect, the 1967 Act had the upper limit, had the upper time limit of 28 weeks from the 1929 Act, and then it was amended. When it was amended,
I'm not following any of this. I don't think it's important now, unless if Miss Smith makes it important to her submissions to tell us all about the 1929 Act. We've obviously got to get to the bottom of it, but I got the impression it was more of a footnote.
No, the court has some detail in paragraphs 5 onwards of Miss Duncan's statement, page 102 onwards of the supplementary bundle, in case that assists. But
fine, well, we can get all that. All I want to know is, are you making a point about it, which I need to know?
My point is really that this is a provision which is focused on pregnant women, what's happening with pregnant women and not the disabled. That's the headline point. That was my first submission. The second submission...
But just so I can understand it, my Lord's point that it's aimed as much as the protection of doctors as of pregnant women doesn't necessarily undermine your point, does it? Because your point is not so much who it is aimed at protecting, but that it is not aimed against the disabled.
Exactly. It's what it's about, what it's doing.
Okay, that was your first point.
The second is that it doesn't express specifically a value judgment on the worth of the lives of the disabled. It doesn't stereotype in that sense. It doesn't say the sorts of things that are said in the cases that I've taken the court to. It simply says, in these circumstances, there may be, provided the conditions are met, criminal sanctions will not apply. That is not, in my submission, stereotyping.
right, you can see, however, that it might appear necessarily to imply a view that the life of a disabled fetus, if born, was worth less than one that was not.
Yes, and indeed, and I accept that this is a very compelling context, but if one takes it outside this context, there are many who might say this legislative provision that has been introduced, I find offensive. So, for example, the two-child rule for tax credits. A family with 3 children. I accept entirely that the context is different, but one has to look at this in principle, because if this applies in principle, then it potentially applies to a broad range of contexts. Might say, well, that is expressing a view about the value of my family. Therefore, that interferes with my private life rights. So that there are many legislative provisions which various different groups may say, well, this impacts on my feelings of self-worth and my feelings of identity. And that again, I repeat, is absolutely not to minimise this context, but it must be addressed at the level of principle in my submission.
Yes, that's an interesting example. Have you thought of any others?
I haven't, but I haven't. I'm sure.
That's what your junior's for. Right, thank you.
Yes, or Mr. Eady, who isn't here. I'm sure we'll be able to supply the court with examples. But yes, I mean, fundamentally, that is just an example. One has to say, if it applies here, when else might this principle be engaged?
Well, I wonder. I mean, I know that you're moving on, but and that we're not making light of any of this, but I wonder whether there really is another example of this importance in which one part of the legislation might be taken to be saying something that is so fundamentally at odds with an absolute building block of a core part of our law under the anti-discrimination provisions. I mean, if you can come up with other examples, yes, by all means.
Indeed, I mean, there are examples in the case law. Elan Kane is an example where those provisions, the law was of itself offensive to Mr. Elan Kane. That's not the basis on which the case was argued, of course. It wasn't considered. But I believe the judgment even refers to that the feelings that the law brought about. But if there's an interference with Article 8 rights each time that the law evoked powerful feelings, that very substantially extends Article 8 rights.
Yes, but I mean, that is an Aunt Sally. You're absolutely right about that, of course. For all sorts of reasons, we get into the whole time in the Article 10 context, people have got to put up with being offended. But it's a question of offended by what? And here, I didn't understand Mr. Croppell to say it is enough for the claimant to come here and say, I find this law offensive. What he says is, she is entitled to say, I find this law offensive because by necessary implication it states that my life as a disabled person who has been born is worth less because of the different treatment of fetuses with the same disability. So that's a much narrower case, which you can't attack simply by saying it's not enough to say you feel offended.
No, but I think the answer to it, and perhaps the point that I'm at least in part capturing by my second submission, is that it's very much being offended by the provision that the law makes rather than what the law says in terms of the example that your lordship gave, which is, well, what if the legislation said X people are Y in very offensive terms? That would be a positive statement. But
yes,
to complain about the consequences of the law that this law has been enacted, and I find the law offensive because it doesn't sufficiently recognise my value.
Well, I think you're slightly understating it. The point is, she's made is that by necessary implication, it devalues the worth of my life. But I think, if I'm misrepresenting your submission, don't accept this. I think you're saying, in this point, it's not enough to say the necessary implication is, or might be thought to be, that my life has less value. It doesn't say that, and it's not trying to say that.
Yes.
Is that implication isn't enough?
Yes, exactly. And I would add that what it does is says, in these particular circumstances, where two doctors certify, and plainly that the family themselves have to want to go ahead with a termination, having had the advice. But that's their choice. It's not the law saying all of these pregnancies should not go ahead, because there will be many families who continue with those pregnancies. So the law is...
Yes, but that doesn't go to the heart of it.
It doesn't.
The point is that the parents have a choice which they wouldn't have with a non-disabled child. So that's what you have to face up to.
Yes, and I face up to it exactly. But it is part of the factual matrix against which the court is looking at whether this legislative provision is itself negative stereotyping. And I accept Mr. Coppell's case would be stronger if it, and of course it wouldn't, but if it said in all these in over 24 weeks, if there is this set of circumstances, there must be a termination. That I accept. I wouldn't necessarily accept for other reasons that there would be an interference, but I accept there would be a stronger case because the law would absolutely be the state. The law, Parliament, would be expressing a value judgment across the board. So one does have to look at it in context, because these cases are always context specific. Always. They have to be decided on the actual facts, and that involves looking at what the law is doing. And a point I'll make in a moment is what else the law does. If I'm saying the law is stereotyping, then one has to look at what the law does and what else the law says. So I've slightly strayed.
Yes, we mustn't get too bogged down on the word stereotyping. That's what it happens to say in the case law. But the underlying concept is that a state body is taking a position, expressing a view that is said, by implication, to devalue the life of the living disabled. I think you appreciate that, but stereotyping is just a word. It's not the heart of the problem.
No, although it's the only test that this court has, and that's why I took the court to the case law, because one has to look and see, well, when given that this taken to its logical extent, given that this is a potentially very broad proposition, that there might be interferences in all sorts of other circumstances, one has to look at the test, and one has to look and see, well, what guidance do we have? When has it been applied? And stereotyping in my submission is a very clear word. The third point I make, and it's again to do with what the case law focuses on and negative stereotyping, is that in practice, when Section 11D is engaged, it involves intensely private decisions about a woman and her medical treatment. So plainly, those decisions aren't published. There's a very difficult and fact-sensitive medical assessment, and Professor Teeler-Ganathan explains just how difficult that is. That actual implementation of Section 11D, again, is not saying anything about anyone with particular medical conditions, and still less is it stigmatising. So that's the third point. And then the fourth point is one of context, that one has to look at the broader context when considering whether there's an interference. So in that respect, can I make two sub-points, still on my fourth submission. The first is set out in our skeleton at paragraph 36.1.
So sorry, I've just been behind noting this down. What is the fourth submission of which you're about to make two?
One has to look at the broader context when considering whether there's an interference. So what one can't do is say, right, look at this specific provision in section 11D. What's being said is that the state is stereotyping the disabled, or I understand what your lordship has said about that word, but I'll just use the word from the case law. So in terms of the context, can I make two sub-points? And the first is set out in our skeleton at paragraph 36.1, and it's this, that in this specific context, there are arrangements actively seeking not to perpetuate discrimination, and that's a reference to the guidance which says, for example, there has to be a non-directive approach if somebody wants
So sorry, wait, where are we?
At skeleton paragraph 36.1. So our skeleton is, I don't know if the court has it separately or in
I don't have it separately, but that's fine, I have it.
Bundle. It's in the core bundle.
I think I'm the only one who hadn't got it, and I have now. So.
The core bundle at 211.
Yeah.
Paragraph 36.1, we point out that the arrangements for abortion provision make specific provision to reduce the risk of adverse treatment. And we say there that the guidance emphasises that support has to be given to any woman who carries a pregnancy to term, even in case of fetal abnormality. And to give the court the reference for that, we don't need to turn it up, it's page 221 of the supplementary bundle, the whole of section 6 of the ARCOG guidance. And the point that we make in our skeleton is that that is one of the relevant measures identified by CEDAW, which is the Committee on the Rights of Women, to mitigate any risk of perpetuation of stereotypes when a legislative provision like this is in place. So that's my sub-point 1 on context. And the second point in my submission is this, that if one is looking at the law and whether the law itself stereotypes, or whatever word one wants to use, then in my submission it's clear that one should look at the broader scheme of the law and what other protections it offers. And that is addressed in paragraph 36.3 of our skeleton. We point out that there are a number of measures which protect and promote equality. And just for the court's note, again, I don't need to ask the court to turn it up. It's Andrea Duncan's witness statement at pages 134 to 135, which set out in detail what those measures are.
Which paragraphs?
I'm so sorry, 1 second. It is paragraph 60. There's a section called Value Under the Law at 65 to 70.
Thank you.
But the key part is 68 onwards.
While we're in that, can I just ask whether you have any observations about this? A little earlier in that statement, page 128, are the list of states, 16 or 17 of them, which allow termination with no upper limit, including for fetal abnormality. So looking at the list of countries there, it's noteworthy, if it's correct, that the issue that we're deciding here doesn't seem to have arisen before.
Indeed.
It doesn't. Maybe it says nothing either way about what the correct analysis is, but it seems, considering the length of time that the legislations will have been in effect in these other jurisdictions, worth pausing on.
Indeed, and that perhaps comes back to my point that when one looks at the cases that have actually considered the stereotyping principle, there is not a single case looking at a legislative provision like this generally, nor is there a case addressing provisions about fetal abnormality.
Well, I mentioned this to you to see whether you were going to seek to make a partisan point about it.
No,
I mean, clearly somebody, if it wasn't going to be these appellants, then somebody somewhere else would have had to take up the argument.
Yes, I think it perhaps is just an illustration of my broader point about if this is right, then it has broader implications. All of these other countries are also interfering with Article 8 rights, but potentially the point goes wider than that, and that's why I come back, I think, to my Ulla point, which is not going further than one can be confident the European Court would go. In my I'm so sorry, my Lord. All I was going to say is, in my submission, if one looks at the issues, and I'll come on to my fifth submission in a moment, if one looks at the potential broader ramifications, in my submission, it certainly cannot be confident that this is how far the European Court will go, that the European Court would say that in these circumstances, with all of these factors, there is an interference. In my submission, one can be confident that it wouldn't, although that's not the question.
Just while we're on this point, Mr. Cromwell makes the point we don't know the details of these provisions. In principle, they might all be cases where this was limited to cases of fatal fetal abnormality. I don't think that's covered by the evidence, was it?
I don't think that's right.
No, well,
we
that's
say,
fine, just explain.
In addition, in some countries where there's no upper limit, it includes abortion for fetal abnormality. But let me turn my back on that question and I'll come back at the end of my submission. My fifth point is this, it's to do with this causation point, and we don't submit that causation is the only factor, and nor, if one reads the Divisional Court's reasons in their entirety, did the Divisional Court say, well, there's no evidence that this provision itself causes disability discrimination. That's simply one factor to take into account when one is looking at all the circumstances. So the final point that I make is this, that the fact that there is...
Sorry, is this the fifth point?
It's the fifth point, that the fact that there is disability discrimination in society generally doesn't mean that Section 11D causes or contributes to that discrimination, or create an environment in which the disabled are stigmatised. And I make the point that was made in questions from the court to my learned friend, which is that the evidence is general. It's directed broadly to the message that the legislation is said to send, or the broader discrimination generally. For example, if one looks at paragraph 6 of Professor Sire's witness statement, and I needn't take the court there because it's been addressed in the context of Mr. Coppell's submissions. But the point is this, that the fact that there is discrimination in society doesn't mean that that's what Section 11D is doing. And
well, up to a point. I mean, obviously, I do see that. But what is said is that Professor Shaw in particular says, and I think also the United Nations Commission says, that 11D contributes to societal discrimination or reinforces a perception that that disabled people's lives are of secondary value. So that is specific evidence, not that it's the cause of all disability, which would be obviously putting it far, sorry, cause of all discrimination, which we're putting it absurdly high, but that it plays a part. And what do you say about that evidence?
Well, then one has to look at what the evidence actually says, because the way that the evidence is expressed in my submission is that it's very much a matter of expression and it's very much a matter of opinion. That in my opinion is that this is what Section 11D does, which is exactly what the appellants are saying. But the broader points that are made about research and so on relate to perception in relation to discrimination generally. Now, the fact that there is a view that this is the message that Section 11D says does not mean that Section 11D causes or contributes to the discrimination which is suffered by protected groups.
Yeah, I mean, the phrase sending a message is a metaphor. I mean, it's not actually very precise. I mean, that phrase simply means that, could be said really, it has that it carries, and if you look at it, it carries an implication that the lives of the disabled are worth less than the lives of the non-disabled. But that's really about the tendency or something that's inherent in the legislation, rather than a statement about how much people actually, how far that message is getting out there. So I'm putting it badly, but you see the point I'm making.
Yes, and it's a point really about, the point is simply this, that if one allows abortion on grounds of fetal abnormality, that sends a particular message, and it's the point that's been made in parliamentary debates, including by Lord Shinquin. But that is not, in my submission, something which meets the test in the case law.
The Secretary of State presented a body of evidence, which we've read. What evidence did the Secretary of State present on the question of the message? What evidence was directed to answering the point that was made, for example, by Professor Singh?
The point is answered in our submissions. We don't specifically answer that.
Sorry, can you speak up?
I'm so sorry. The point is answered in our submissions, yes. and I rather than in evidence.
Yes, I mean, I obviously it was a slightly loaded question because I wouldn't have asked you if I knew where the answer lay. But in practice, what the Secretary of State has done here is not to say, no, these experts or academics expressing opinions are wrong. What you've effectively done is to say that's not the right question. We don't respond to it.
Yes, and it would be very difficult for the Secretary of State to say that, because it's a view, and one can't quarrel if that's somebody's view.
Yeah, but experts, actually, I suspect these. I don't know whether CPR 35 was complied with, but you're right. This is simply an opinion. Professor Shiod doesn't say, I have spoken to 100 people with disabilities and said, have you heard of Section 11D? How does it make you feel? I'm quite sure she's sincere and means what she says, but what she is saying is, this is the kind of thing that you would expect to have this effect.
Yes.
And that is...
It's not really a question that requires expert evidence. It's a question of opinion which would be held by a number of different people, and we know from parliamentary debates that it's certainly Lord Shinquin expresses those views. He is himself disabled. He doesn't profess to be an expert generally on whatever one would need to have expertise in. And similarly, the appellants don't profess to be experts. Nonetheless, that they express that view. So in my submission, it's a view. It's not, the Secretary of State can't say that feeling is wrong, because I'm
sorry, Ms. Smith. What you've got there is a range of evidence, ranging from the personal views, which I appreciate you can't be expected to take issue with. You've then got a level of professional evidence, which it might rightly be described as being opinion, but by people who are closely associated with this particular problem. And then you've got the views of at least one institutional organisation, more than one, with the Committee on the Rights of the Disabled, and also MenCap, for example, which came later, I appreciate, but it took you by no surprise what they were saying. What makes you say that it's not open to the Secretary of State simply to put in material from some equally well-qualified person saying, well, I've spent my whole life researching this and I don't find this to be the case at all? Highly exaggerated or simply an outlying opinion? Or is the reality not the fact that this is the sort of thing one would expect to find? And there's no point in trying to find people who think the opposite because they aren't there.
I think our point really is that the test isn't met, and to have perhaps gone away. We accept that the feelings are powerful, and we certainly can't counter that by evidence. The point is that for all the reasons I've given, the test isn't met. And if one looks, for example, at the evidence of Professor Sile, or Shaw, I'm not sure how to pronounce her name, what she is saying is Section 11D powerfully communicates a message that I'm reading from paragraph 5 of her statement. She says, "It's my view that institutional stigma, such as that inherent in legislation, has a powerful role to play in either countering or promoting and maintaining negative stereotypes." Well, the answer to that from the Secretary of State's perspective is yes, we understand that that's certainly how some people feel. But there is part of my answer to it is yes, but there is other legislation as well. But the Secretary of State, in my submission, there's no need for evidence on the Secretary of State's part to address this question because the 5 reasons that I've given the court just now don't require evidence. I don't know if that answers your Lordship's point, but I accept we haven't gone away and asked somebody what do you think about Section 11D.
It calls into question, doesn't it, the treatment of this issue in the judgment, which we're looking at, which takes us back to 102, where it's simply that's all the evidence that we have, but we're not persuaded.
Yes, and I accept that paragraph 112, the reasoning 102, yes, that the reasoning is compressed, but actually it's expressing several different things in that paragraph in my submission.
You'll come to that, will you?
I'm very happy to go. In my submission, it's yes. I'll take the court to the passage specifically. And one has to remember, of course, that there were a number of arguments being advanced, and the point wasn't argued in the same detail as it's being argued in this court. In terms of the judgment, one has to look at paragraphs 100 to 102. Mine is buried. So the court makes several points. Mr. Coppell, not orally but in writing, has criticised paragraph 100. But paragraph 100 is simply a response to a point made by the appellants that Article 8 is engaged because this is about becoming pregnant. And the point that the court makes is that the fact that Article 8 relates to the fact that Article 8 applies to or is engaged in the context of abortion, and that rights may be interfered with if abortion isn't offered, doesn't say anything about the rights of the appellants themselves. It's just a preliminary point. The second point at paragraph 101 is again saying, and I've obviously expanded on it, that if one looks at the case law that the appellants are relying on, the negative stereotyping in those cases is obviously and significantly different from this case, and I've unpacked that in more detail, I hope, in my oral submissions just now. And then the court says that legislative provision doesn't perpetuate and reinforce negative cultural stereotypes to the detriment of people with disabilities. Well, it doesn't meet the test. And again, I've set out the reasons in more detail.
Can we just pause here? Something I've been puzzling about. The claimant could put their case in one or both of, either or both of two ways. They could say it has a direct impact on me that 1.1d by implication devalues my life as a disabled person. I'm aware of 1.1d. When I think about it, it upsets me for that reason. That's a direct impact of 1.1d on me. The other is to say (1.1d) contributes to, no one suggests it's the only reason, but it contributes to a negative stereotype of society, the people I encounter every day in my life, about disabled people. And it therefore affects me indirectly because it affects their perception of me. And I think the reasoning is rather different in the two cases. Speaking for myself, you can challenge this if you wish, I have no difficulty with the first. There may be a separate question whether it satisfies the test under Article 8, but it doesn't in the least bit surprise me that a disabled person, if aware of 1.1d, would be offended by it.
Yes.
Perhaps not everybody would, people are different, but it's an understandable reaction. But the second one seems to me less obviously so. I feel impertinent talking about it because people with disabilities will know this much better than me. But attitudes, mostly we hope subconscious attitudes devaluing the value of people with disabilities, are pervasive in society and have all sorts of deep roots which I wouldn't wish to say anything about. I have plenty of people with proper expertise in how societal attitudes to disability come about. But that being so, the idea that this very particular provision makes any real difference to how people in the street treat disabled people might be thought to be rather remote. I'm expressing a view myself, but you can see it's a quite different argument about the two different kinds.
Yes.
Is that a helpful way of looking at it? Do you want to build on that in any way?
Yes.
Or
Your Lordship is absolutely right, and I understand the case to be put in the first way. And of course we say, yes, but that's not enough for there to be an interference with Article 8 rights. And indeed, the second point, precisely so. And I'd invite the court to find it simply as a that must be right. That I would suggest most people probably don't actually know about Section 1.1d. So it's very much that the way that your Lordship put the first way of putting the case.
Yes.
And for all of the reasons I've given, however the case is put, the test is not met.
it looks as though in 102 the court was concerned with the second of those points.
Yes, it focuses on that specific point, which was one of the points made in the Secretary of State's detailed grounds and skeleton argument.
Is the second sentence of 102 a recital of your submission?
Yes.
Or is it, well, I appreciate it agrees with your submission, but is it to be taken as being the court's conclusion on that question as well?
Is that the sentence beginning, we are not persuaded?
No, that legislative provision does not perpetuate and reinforce negative cultural stereotypes to the detriment of people with disabilities. Second sentence.
Yes, in my submission, that's simply a way of saying that Section 11D doesn't interfere with Article 8.
No, I'm just asking who's speaking. Who's speaking there? I had read it, speaking for myself, to be that the court was accepting your submission.
Yes.
But you had said it, and the court is adopting that,
Yes.
and that is the court's conclusion. Because my question for you is, how can that be so, bearing in mind the evidence that it had received? I mean, is it not? It's already referred, not that long beforehand, to paragraph 95, Professor Singh and Professor Hastings, which is set out. Is that sufficient, just simply to say
Well,
it doesn't perpetuate and we're not persuaded?
It's a reasonable comment for the court to make if one digs down into what the evidence actually says. I accept that the reasoning is brief, but ultimately the court's conclusion is right for the reasons that I've given in my oral submissions. Because if one drills down and actually looks at what the evidence says Section 11D is effectively making a statement that. And
you didn't call any evidence that said the opposite. It's not saying. Well, of course, we accept so far as it goes the evidence of these professionals, but we don't really think it's on point.
yes,
And therefore, it effectively read at face value. Not sure there's any other way. The court is simply rejecting the evidence, and clearly that touched a particular nerve because it was that particular paragraph that led to MENCAP becoming involved.
yes, but my submission and certainly the submission that the Secretary of State made wasn't completely focused on causation. It was never submitted that causation was the determining factor. So it's simply an additional.
No, that's the next point.
Yes.
I'm concerned with the second sentence,
Yes.
which simply flatly disagrees with people who, whether they're CPR experts or not, are individuals and committees working in this field.
Yes.
Yeah, for what it's worth, I read the final, rather longer sentence as explaining the second sentence.
Yes.
So, I'm not sure that perhaps that you were both there already, but that's.
Yes.
I don't think it'd be right to read 2 by itself and say it's unreasoned.
Yes.
The reason I thought was the one that followed in the next sentence.
Yes. One has to read the entirety of 100 to 102.
Thank you.
But in effect, this is a substance challenge rather than a reasons challenge, and we submit that the court has got this right.
Yes. Well, I'm sorry, this is an important point, so we spent a lot of time on it, but is there more you want to say on your 5 reasons why this isn't a case of absolute type discrimination?
No, there isn't. Can I just make a point about the views of international committees, and I'll do this as briefly as I can because it's all in writing. This applies in my submission across the board to all of the issues. And in effect, we invite the court to look at the reasons given by the Divisional Court of paragraphs 40 to 47 and 104 to 108. And the Divisional Court effectively made 2 points. A, that there is no international consensus on these issues. And B, even if there was, that couldn't be determinative. Now, we've addressed that in our skeleton at paragraph 38. Court's note, and given the time, I won't repeat that now. Could I just draw the court's attention to the complete passage from the other committee, CEDAW, which is at footnote 8 of our skeleton, attached, I think, to paragraph 38. Yes, it's paragraph 38.3 of our skeleton, where we say that the appellants haven't cited the full CEDAW report. And then, of course, the court won't be surprised to hear that we rely on what's said in AB and also in SC. And I can give the court the passages, but I'm sure the court's very familiar with those cases, and I won't take up time now with that. But we basically rely on the divisional court's reasoning that there isn't a consensus, even on interference. And even if there was, that isn't determinative, because the point is that the fact that the committee thinks that abortion shouldn't be available on particular grounds does not mean that this legislative provision itself is an interference with Article 8 rights. It's simply the view of the committee on whether the UK should offer abortion on these grounds or not, which is a different question. So that takes me to the third part of my submission, which is about in accordance with the law. And we filed the supplementary skeleton. That we make 3 points here, and we say that this is important. The first point is this, that the court has to ask the right question. And the question is whether the specific interference at issue in this appeal is in accordance with the law. This is not an occasion for a general review of the quality of the law on abortion, and I'll make that proposition good in a moment. And the second point is, once one looks at the interference, assuming I'm wrong, and it isn't an interference to have a legislative provision which says these are the circumstances in which abortion is available, how does the in accordance with the law test apply? The answer is that the law, so far as the appellants are concerned, in relation to the interference that they assert, the law is perfectly foreseeable and accessible. Indeed, it's why they've brought this case. And I'll unpack that in a moment. And the third point is we say that the argument still fails, even if one were able to perform a general analysis of the quality of Section 11D. But the first and the second submission are important, we submit. So before I deal with those points, could I just address the legal framework? And I need to do that. I won't repeat things that have already been said, but I need to do it to make good those points. So could I invite the court to turn up Bridges, which is at the First Authorities Bundle, tab 15. It's common ground between the parties that the principles are as set out in paragraph 55 at page 431 of tab 15. Could I just invite the court to look at the second principle set out there, paragraph 55.2. The legal basis must be accessible to the person concerned, that those words are important, meaning that it must be published and comprehensible, and it must be possible to discover what its provisions are. The measure must also be foreseeable, meaning that it must be possible for a person to foresee its consequences for them, and that it shouldn't confer a discretion so broad. So what that is doing is talking about what's the point of, or what's one of the main functions of the in accordance with the law requirement. It's so that people know where they stand. It's so that they know what their rights are. It's so that they know the circumstances in which those rights might be interfered with. It's so they know how to bring legal proceedings, or can bring legal proceedings, for example. So that is important. That's important to the general submission we make. The other point, just to draw the court's attention to in this judgment, is paragraphs 59 and 60. Mr. Squires invited us, paragraph 59, to have regard to hypothetical scenarios which might arise in the future, for example, and then the court gives some examples.
So sorry, which paragraph you want?
59.
Yeah, thank you.
And then the court says at paragraph 60, 3 lines from the bottom, we don't accept that it's necessary or helpful to consider hypothetical scenarios. We consider that what must be examined is the particular interference with Article 8 rights which has arisen in this present case, and in particular whether that interference is in accordance with the law. And then the court goes on to say, just above B, this is consistent with the approach of the European Court, which usually asks whether there's been a violation on the particular facts of the case. So it's very much focused on the interference. And then the final point, and I agree with Mr. Coppell on this, is about the relativist approach. And that's set out in a number of authorities, which basically says, well, one doesn't apply the in accordance in the law test in a vacuum, one has to look at the context. So those are the legal principles in the background. Can I then turn to the 3 propositions that we've made in our supplementary skeleton? And the first is that asking in general terms whether section 11D is in accordance with the law does not answer the right question. And we say that if one looks at any Strasbourg case or any domestic case which considers whether or not an interference is in accordance with the law, it always looks at the particular interference asserted. And I'll take the course in a moment to A, B and C. And we submit that follows as well because of the fundamental nature of the way that rights under the Convention are examined. They're examined on an actual rather than hypothetical basis, and they're examined in the context of a claim advanced by an actual victim. The other point to make about in accordance with the law is it doesn't feature in a positive obligation case, and nor does it feature in cases about Article 14. So it's very much focused on cases where there is some kind of positive interference with a right, and the reasons that it's engaged in those circumstances are those set out in that extract from Bridges that I took the court to.
Sorry, I got lost on positive obligations again. What's the point you're making?
The point I'm making is this. We're saying the court can't just look at section 11D in general. Got to focus on the particular interference asserted in this case, which is section 11D stereotypes. That's the interference. The reason that the context is so important flows from the nature of the way that convention rights are examined, which is on actual facts by a victim, and second, because the question of in accordance with the law only arises in the context of a negative interference. So take a classic example, somebody who's being deported. That is a direct interference with their Article 8 rights. But for example, in a case like Elan Kane, where one's asking, is there a positive obligation, there isn't an examination of in accordance with the law. And that, in our submission, underlines what the requirement is about. Now, the reason I make that point in this case is that the points that the appellants make are made from the standpoint of pregnant women, doctors, and the unborn. The points that are made on accordance with the law are advanced from that standpoint. But there's no woman or clinician in this court saying section 11D isn't sufficiently accessible or foreseeable. Indeed, the court's got evidence from the professional body saying it works. But the more important point in the context of the way that Mr. Coppell's advanced the case is this, that Mr. Coppell says, well, the rights are the same because we're complaining about section 11D because this is what happens to the unborn. But that is wrong, we submit, because that's a complaint about the right to life of the unborn. So in effect, the problem from the perspective of the unborn, as the case has been put, is, well, abortions can be certified lightly. They can be certified for a range of conditions, but that's not the question. That the issue for the unborn is losing their lives, but the unborn aren't the holders of rights. So
Your point, perhaps I put it in my own words, see if I've got it right. Your point is the interference is simply the fact that the disabled unborn are treated differently, and in a way which makes it easier for an abortion to take place. And as it were, how much easier or exactly in what respects they're different isn't really the essence of the point at all.
no, that's about the rights of the unborn. That what the appellants submit is that this interferes with my Article 8 rights because it's negative stereotyping. The point from the perspective of the unborn, if one looks at the underlying purpose of Article 8.2 in terms of telling people what they need to know, one couldn't have procedural safeguards. Well, the procedural safeguards the unborn would need is somebody coming in to say, well, no, you shouldn't do an abortion here. But that's not what this case is about, and it can't be what the case is about. So for that reason, and we say it's evident from all of the case law, the question has to be, is the interference, the message that the legislation sends, in accordance with the law? So that's the question, and my second proposition answers that question, because we submit that when one asks the right question, it's clear that there's no issue in this case. And the fundamental reason is that the appellants are well aware of the fact that abortion is available on grounds of fetal abnormality. That's why they bring this claim. So can I invite the court to turn up A, B and C, which is at tab 2 of the...
Before you leave this point, this question about whether it doesn't arise at all in the positive obligation case, that doesn't seem to form part of the reasoning in the divisional court, does it?
No, it doesn't. But the appellants filed a supplementary skeleton, and we obviously got...
Yeah, I understand why you're answering it. I'm not complaining at all, but they had a more direct route to it.
Yes, exactly. And certainly in our first skeleton, we say, look, even if you take the case on its own merits, it's right. But in my submission, it's right in my submission in this court that the right question is answered, and that I draw the court's attention to this point. But your lordship is right. The divisional court decided on what's going to be my third point, which is it's right that this is reasonably practicable, in effect. So the second question, what's the answer if one asks the right question? Is this, how does the in accordance with the law requirement apply when the complaint is that the interference is negative stereotyping? Now that, in my submission, the fact that that's the question rather illustrates the weakness of the point on interference, because Article 8, when it's dealing with interference, is something directly interfering with somebody's rights, as opposed to something that, in this case, the legislative provision. I won't get back into my submissions, but in this instance, before I say anything else, can I ask the court to turn up A, B and C, which is at tab 11 of the second authorities bundle. We're short of time, so can I capture the point in a nutshell? A, B and C was three applicants who were saying there'd been a breach of their Article 8 rights because of non-availability of abortion in Ireland. And two of them were directly complaining that they'd had to travel elsewhere for an abortion. And what the court says is, and I'll take the court to the passage, well, there's no issue in accordance with the law because you knew you couldn't have an abortion. Later, the court goes on to criticise Irish law and how it was set up, and it's something that the appellants relied on in their supplementary skeleton. But it's particularly noteworthy then that given that the court has those criticisms of Irish law in general, it doesn't at any point take those into account when it's considering the specific interference asserted by the first two applicants. So can I just ask the court first of all to look at, I'm going to try and cut this short. So Irish law in a nutshell is that there was, in the Constitution, there was a question about whether there was a real and substantial risk of life to the mother, but that hadn't been implemented in legislation. So for the court to note in the judgment, that's addressed in paragraphs 36, 37, 41 and 44.
36.
41, 37 and 44.
Sorry. 36, 41.
37.
So you're going back to 37.
Sorry, yes, this, no, I'm misreading my own note. 36, 41 and the citation of paragraph 37 in paragraph
I see,
41.
yes, okay.
I'm sorry. Paragraph 44.
Right.
So, again, just to navigate, paragraph 216, the court concludes that there is an interference with Article 8 rights. That reasoning is immaterial here. And then the in accordance with the law test is dealt with in three short paragraphs at 219 to 221. It doesn't perform a general analysis of whether or not the law is certain or any of those things. It certainly criticises it later when it's dealing with the third applicant. It simply says, yep, that the interference about which you're complaining about, that the law is foreseeable and accessible in your case. The court goes on to deal, when it's dealing with the third applicant, and the consideration there begins at paragraph 243, the complaint that the third applicant makes is that the Irish state has only got this provision in the Constitution and not in legislation, and also that it hasn't introduced a procedure by which she could have established whether she qualified for an abortion. And the court says that's a positive obligation type situation, and then it goes on to criticise the Irish legislation, the fact that it's only in the Constitution, it's not in legislation and so on, and those are points that the appellants relied on. The point that I derive from this case is 2 points. The first is that the ultimate conclusion of the court is that the way that things are structured in Ireland means that there would be a chilling factor in the consultation process. Well, that issue doesn't arise here. It's also striking that ultimately the court is focused on that rather than the quality of the law. In contrast to our situation in this country, the Irish test wasn't in legislation, it was just in the Constitution, so there was no effective means of addressing it. But the second point I make is this: the court does make these criticisms of the legislation. So if the in accordance with the law test required a general appraisal of the abortion laws in general, it would have done that under the first and second applicant's case, and it doesn't. So we say on the facts of this case, the test that we say applies, my second proposition, is clearly satisfied. And one could, in principle, test the point by saying, well, what is it that the appellants would need to argue that this is in accordance with the law? Because if, from their perspective, if the legislation said abortion is definitely available for the following medical conditions, that would satisfy the requirement, but that's not what their case is about. They are arguing for a broader restriction on the laws on abortion, and that's not this case. So can I then take the third point?
Yes, Ms. Smith, I'm a bit troubled about time. It's not a criticism of you because we allowed Mr. Croppell quite a bit of a late start as well. But the fact remains, we can sit to 4:30, and we've necessary, we'll sit a bit longer. We've got to leave some time for Mr. Croppell to reply, so though I don't think he'll have to reply in any detail. Can you accommodate the rest of your submissions in such a way? You've still got justification to go.
Yes, although that I can do a lot of cross-referring there. And not
Okay,
make it,
well, I'm just laying down a marker.
Indeed.
We will go on to 4:30. We will take some persuasion that we need to go any longer than that. So great.
Indeed.
I want at least to have a
and I
meeting
have that in
shortly
mind.
afterwards.
My Lord, I'm trying not to speak too quickly, but I have a bad habit of doing that. So,
don't worry, keep going.
So the third point is simply that we say this doesn't arise because the first and second submissions knock it out. But to the extent that this court is entitled to look at section 11D generally, we say that the in accordance with the law test is met fundamentally for the reasons given by the divisional court in Bright and in our skeleton at paragraphs 40 to 42 and in our supplementary skeleton at paragraph 9. So I can make 3 brief points as to why we say that. The first is the context. The context includes the interference which is being alleged. So even if my first and second submissions are rejected, it comes in at this point. The second point of context is that doctors are regulated by their professional obligations. And the third point of context, if I can describe it in this way, is this really isn't simple in medical terms. And could I just invite the court to look at Professor Teeler-Gathan's evidence at pages 160 to 162. And I'll give the court the paragraph references now. Paragraphs 72 to 77. He explains why it's complicated, but effectively, I'm sure as the court will understand, there are interacting conditions, there are the uncertainties of medical knowledge, there is dealing with a fetus, there are a whole range of factors that he mentioned that makes this incredibly difficult. So that's the first point. My second point is simply the bright point that the law doesn't require certainty. And in that respect, see paragraph 9.2 of our supplementary skeleton, which also references what the Supreme Court said in A, as well as Bright. And the third point, and again I won't get into this in detail, is that there are safeguards. First, professional obligations. Second, there has been a prosecution in the past, but it is entitled to take into account that doctors generally do act in good faith and take their responsibilities seriously, and that's a point that's made in our witness evidence.
Have you anything to add on the question of the extent to which, in principle, whatever it may say in practice, the RCOG guidance can be relied on to fill gaps in the actual hard law?
We would submit it's part of the context. We don't submit that it's law for the purposes of Article 8 in that sense. But as I hope I've made clear, it's a multifaceted question. So to the extent that issue arises,
Okay, thank you.
part of the picture. But fundamentally, we put our case on the basis of the terms of Section 11D and the fact that this is incredibly complex, that the medical decisions are incredibly complex and very fact sensitive. We don't seek to put it on any other basis than that. The court might want to note that in NIHRC, at paragraph 20, Lady Hale expresses the view in that case that the legislation is in accordance with the law. And the court may also wish to note that in Bright, at paragraph 34, the court makes a similar point to the point I've made here, which is, hold on a minute, this question doesn't actually arise for one particular set of claimants on the facts.
time is short. Can we just see
Yes.
the NIHRC para 20?
Yes, of course. NIHRC is tab 13. While the court's in this judgment,
Well, let's just look at the paragraph that you had in mind.
paragraph 20.
Well, that's rather strong from your point of view, isn't it?
Yes.
Right. Where else did you want us to go?
While we're in this case, because it's going to be relevant on proportionality, could I just invite the court to look at paragraph 6 of Lady Hale's judgment, which is what she says about women and women's rights and interests while we're here.
Yes.
So I'm realising that clock is wrong.
I know. That's why I've been.
I'm so sorry. I didn't realise that clock is wrong. So
I'm sorry. I did refer to it at the beginning of the hearing, but
Yes.
right. Well, you are. You thought you were much more relaxed because I was a bit puzzled just how relaxed you were being. Well, look, let's just take stock. You have submissions on justification.
Yes.
Do you, Mr. Tropple was pretty short on those.
I can be sure.
It is now 4:15 or 4:14 to be exact. Can you be 5 minutes?
Yes. Let me try without going too fast. So, first point: what has to be justified? Article 8, it's the interference. Article 14, it's the difference in treatment. We've submitted in writing that there isn't a difference in treatment, but nothing turns on that because if there is, it's justified. So 2 issues. First, margin. The divisional court was essentially right for the reasons it gave. So far as A, B and C is concerned, once the court looks back at A, B and C, the court makes clear that there's a broad margin simply because of the acute sensitivity of the context. The point about consensus is the court says there is a margin. Is it reduced because Ireland's going against the grain? 5 points on margin. A, can't read the divisional court's judgment in isolation. It all has to be read together. 2, obvious point that abortion is intensely sensitive and controversial. 3, Parliament has actively debated the very points which are made in this case. 4 is the McConnell type institutional and constitutional competence point. And 5 is simply to address the consensus point. A lack of consensus increases the margin. The point about A, B and C is that it's what I submitted, so it doesn't take things further. What one could simply look at A, B and C and say, aha, abortion context, broad margin. And then we've made the point about NIHRC in writing. In terms of the narrow margin being justified because this concerns disability discrimination, 3 points. A, the correct approach is a factorial one. See our skeleton at paragraph 45. B, as Lady Hale said in NIHRC, this touches on the most intensive issues so far as women are concerned. And the final point to make is that this, and it's a point that my Lord Justice Underhill made in argument, this question has to be answered in the context of the actual interference. A, the interference that's relied on, and B, the actual practical consequences of that interference. And the authority for that is Elan Kane. See paragraph 57. And then in terms of error in application, we say that the divisional court didn't make any error. See our skeleton argument at paragraphs 54 to 66. Just to make a point in response to Mr. Coppell, which is to say, well, why don't we just say for certain conditions, let's just say, well, you should have you could have had a diagnosis earlier. In my submission, that's introducing an impossible kind of value judgment as to when women should have had tests, when they should have considered the consequences, and it's dealt with in the evidence. It's dealt with in Professor Teeler-Gnathan's evidence. He deals with both late discovery of pregnancy, late diagnosis, and a combination of factors. But to say, well, what one should do is set out a list of conditions that can be diagnosed before 24 weeks, or introduce some kind of judgment that the woman's acted unreasonably in terms of when she's seeking an abortion, in our submission is simply wrong. I'm going to stop there because the other points are made in our skeleton argument. We submit that, again, much of the argument on this ground is about the merits, and we say that ultimately the question here is really whether Parliament made the right judgment, just as that was the question in SC. Did I meet my 6 minutes?
No, Ms. Smith, you've done that very well. Do my lord and my lady have any questions for you? Right, Mr. Coppell. You have, if you need it, but replies should be pure replies, until 4:30.
My Lord, on interference, Article 8(1), the Aunt Sally which my learned friend sought to erect is well, if the claimants are right, then anybody who gets offended by legislation could have an Article 8(1) claim. That is not how the principle is expressed in the Strasbourg case law. I shan't go back to the cases, but when you return to AXU, to RB in Hungary, to Levitt and Austria, what you will find is that the test is focused on fundamental aspects of personal identity, ethnicity in the case of AXU and RB, and in Levitt, being a survivor of a concentration camp, which the court was happy to identify as a group. But we say that disability is directly analogous with ethnicity as part of that core identity, which is part of the legal test. The second point on the test is that we say, reading the test as stated by the Court of Human Rights, that this is a subjective test, i.e. it's to be looked at from the point of view of the disabled person. So it's simply not good enough to say, well, we have this legislation which might convey an unfortunate message, but that's not what we meant. That's not what we're intending to do. The question is whether it impacts upon the self-worth, self-confidence, identity, etc. of the individual, and that has to be looked at from their perspective. And I would encourage you to go back to Professor Shaw's evidence and also to Professor Hastings' evidence at paragraph 7. Professor Hastings does give evidence of the views of persons with Down syndrome on the question of screening and termination of fetuses with Down syndrome. And Professor Shaw, although she doesn't address section 1(1)D specifically in her research, conveys an opinion based on her considerable experience, both that legislation can create stigma and that stigma has a real impact on persons with intellectual disabilities. On the international committees, my learned friend says, well, there's no consensus as a matter of international law, because look at what the CEDAW committee has said about abortion on grounds of fetal abnormality. But on the issue of engagement, of expertise going to interference with Article 8.1 and the stigmatising effect of legislation such as this, there is no disagreement by CEDAW. They align themselves with what has been said by the CRPD committee. They then draw a different conclusion as a matter of what is required by their convention in response to that. But there is no difference between them at all on this particular question of expertise. In accordance with the law, I refute the submission of my learned friend that I'm somehow focused on hypothetical facts or hypothetical cases. Our case is very much about the individual particular facts of the applicants and of disabled persons like them. And the features of Section 11D that we complain about as being contrary to in accordance with the law are features which centrally contribute to the message which is conveyed by the legislation, the breadth, the vagueness, the discretion, the lack of safeguards, and so forth. One simply can't draw a line as the respondent seeks to draw, and it simply can't be enough for the respondent to say, well, these appellants are aware that abortion is available on grounds of disability without time limit. That can't be enough. You might simply have said it, or it might simply have been said in the Gillen case, that the applicants were aware that they might be stopped and searched. That wasn't sufficient. We also refute that the professional obligations of doctors are somehow an answer to the problems with Section 11D. There is no ethical guidance, see RCOG report, and it's very difficult for any doctor to be called out as contravening Section 11D, difficult if not impossible. And finally, on the question of in accordance with the law in the Northern Ireland Human Rights Commission case, can I ask you to turn back to that, please?
Yes.
My learned friend referred to Lady Hale at paragraph 20.
Yes, just give me a moment. Yes.
Page 294 of the volume 1 of the authorities.
Yes, paragraph 20 is
Paragraph
what she
20.
referred to in 294. Yes.
Yes. So what she is referring to, of course, is the state of Northern Ireland law, and she draws a brief comparison with the law in the rest of the UK, and the equivalent law in the rest of the UK is Section 11B and C of the Abortion Act, not Section 11D.
So I see.
And in fact, in accordance with the law was not an issue on the appeal. See Lord Mance at paragraph 81 and Lord Kerr at paragraph 269. So there was no significant argument.
No.
That's right. I think I said finally I've got one more point. On justification, my learned friend referred to the value judgment, she said, which would be inherent if Section 11D was less accommodating for conditions which could be detected early in pregnancy. And my answer to that is paragraph 46 of our skeleton argument, and the quote from Mr. Justice Horner in the High Court of Northern Ireland is that once a fetus becomes viable, he said, there was an obvious counterbalance to the rights of the mother, as she will have permitted the fetus to develop so as to become capable of an independent existence. So once you get to viability, the balance the balance of the various considerations changes. It's not simply value judgment, it's balance, and it's also whether Section 1.1d is really necessary for those types of conditions. Those are my submissions in reply.
Thank you very much. Well, I would just like to thank both counsel and those behind them for their cogent and succinct submissions. The argument has inevitably been in somewhat dry legal terms, but I think I should repeat what I know I've said already, that we are very well aware of the profound human issues involved. We will need to take care to consider our judgments, and I can't say when they will be available, though it's unlikely to be very soon. When they are ready, they will be circulated to council on the basis recently elucidated in the General Council of Wales case, which the lawyers here will be very familiar with. They can explain to the others so far as necessary, but I do want to emphasise that the restrictions on the use to which the draft judgments should be put, and who, therefore they should be circulated to, need to be very rigorously observed. We will obviously at that point consider any disputed submissions about consequential orders. Thank you all very much.
It's a strong look.